practitioners are able to deal with that that challenge that is often presented to us as either people in organizations who have to deal with it, or legal practitioners who are giving advice, or mediators who are trying to assist in dealing with it. It really is an unbelievably tricky subject. And as we were preparing as a panel, this was an issue that came up over and over, how tricky the subject is and how difficult it is to deal with it effectively. It's a very current issue. We've seen an increase in these matters arising, and it's also very controversial. I guess that has to be expected if we live in a culture where there is such a challenge related to gender-based violence, and how that will often then just spill into the workplace. And also we have a history that valued and probably iconized authoritarian and hierarchical behavior. And that too seems to easily erupt into bullying and harassing behavior in the workplace. So we really do, in this context, have our work cut out for us. But there has been a very strong push to address this in law, in civil society, and also in workplaces. And we see that workplaces have been targeted as a place where there is an opportunity to make a difference in terms of educating employees and taking a stand as employers on what is acceptable and non-acceptable behavior. So today, obviously you all come from very different backgrounds. Our participants today, looking through the list of attendees, I noticed that there are many attendees who are from HR practices and employment relation practices and wellness divisions within organizations and companies. So you'll be looking at this topic from a very specific perspective. There are also a number of lawyers and consultants who are obviously interested in advising your clients appropriately, and hopefully we'll be able to offer you some guidance and insights today. And there are also a number of mediators and potential mediators who have signed up for the webinar. So we're really hoping that we'll be able to deal with a whole lot of information which will make your jobs easier as you go back into your work area. I think we have an amazing panel of deep experience and expertise to guide the conversation, and the aim is really for it to be a conversation today. So we'll be conversing with each other, and we'll be keeping an eye on the chat to pick up on any questions that you may have in relation to the inputs that we'll be giving. Just to introduce our panel, firstly, Keshni Naicker. Keshni is a partner at Bowmans and in their employment practice specifically, and she has been involved in many investigations into bullying and harassment. And she advises clients on this and gives them a good idea of how to act in order for them to approach this strategically and effectively. So we look forward to really gleaning from that experience. Keshni is also a recently accredited mediator, so she's been looking at these issues from that perspective as well more recently. Welcome, Kesh. I'd also like to introduce Amandla. Amandla is also from Bowmans. In preparing this introduction, I was excited to see that the International Employment Law Association last year saw her and recognized her as one of tomorrow's leaders. And today is probably tomorrow for you, Amandla. So we look forward to being led by your insights here. Amandla is also in the employment division and deals with these matters on a regular basis, and is also on the National Committee for SAS Law. And I know there's been some emphasis on this at SAS Law too. So we have a lot of information to get out of Amandla. Thanks, Amandla, for being here. And then finally, Angela. is our final panelist. Angela is a social worker by training, and her social work experience has always been focused on the workplace. She has a corporate career and has worked for many big financial institutions and in the mining sector, where she has focused on employee relations and organizational development. And it's such an interesting combination, the social work, organizational development, and employee relations when it comes to this topic of bullying and harassment. Angela's actually been dealing with these cases as a mediator and a facilitator, and also as an advisor since the 80s. So I'm sorry to give your age away, Angela, but that level of depth of experience is so valuable to us when we discuss these issues. Yeah, my name's Marion Scher. I'm a director at Conflict Dynamics, and we do have a number of these cases coming through our books. So people requesting mediators to deal with bullying and harassment matters, and we do a lot of training to make sure that that companies and clients, but also mediators, are well skilled in how to deal with bullying and harassment in the workplace. A thank you immediately to Craig Holscher, who's behind the Conflict Dynamics name on the screen. Craig is just ensuring that technically we're all safe and sound for the time we have together. Good. So now that all the introductions have been done, I think the first question I really want to ask is to Angela to dig into that wealth of experience. And Angela, I'd like to ask you, what is the first thing that comes to mind when you're asked to deal with a harassment or bullying case?
Well, thanks, Marion. Thanks for the introduction. The first thing, besides often wishing, oh my gosh, I could run away, especially when I get into the dynamics of it, this is going to be a really tough one. And your comment about it being tricky is just so true, and all my colleagues involved will agree with that. But besides that, the honest truth is that I've learned over the years that I use a particular mantra to guide me, to highlight some of the difficulties and challenges that will be needed to navigate what is usually a really, really bumpy ride. So I have got 4. The first one is, this is going to be very emotive and emotional. The second is, this is going to be a complex issue. The third one is, this is going to be a very disruptive issue. And the fourth one is, I'm going to see a lot of divisiveness as we go through trying to deal with the case. In terms of emotive, people involved, colleagues, workmates, families, friends, whatever, feel very strongly about what has happened, what people are accused of, if they think it's fair or unfair. So emotions are very, very high. Secondly, it's complex because both bullying and harassment behavior can lie or can be seen to lie along a continuum. Of course, a continuum goes simply numerically 0 to 12, from what they call lower level to higher level to behavior. So, for example, in sexual harassment, it might be from innuendos and offensive, smallish jokes to actual physical assault. And that makes it, the fact that there's a range of behaviors makes it very difficult and complex because people have different responses. So somebody can walk into this room or to a room where the 5 panelists are, 4 panelists, and say something, and there might be 4 completely different reactions. So very often what people are feeling strongly about is the fact that they don't agree with the impact of a particular behavior on a person. They're saying, oh, so-and-so is overreacting, or the opposite. They're not reacting enough. I would be really offended and take action in what I've just witnessed. So that's where the level of complexity comes in. Disruptive, because of the first two, relationships and work performance can be negatively affected, especially within teams. Some are big teams, some are very small teams. What has happened ripped the team apart. And then it leads to fallout. And in my experience, I know that the fallout from harassment and bullying, and in my experience, especially sexual harassment, can last in an organization. The longest I've witnessed is 3 years on from a particular case. People are still at loggerheads with each other, and there's a lot of unhappiness, and people just can't settle after they believe somebody's either being treated too leniently or too harshly. Divisive is that people take sides. And that just feeds into all the other complexities. But when I go into these cases, I just had these 4 words around me: emotive, complex, disruptive, and divisive. And as we go over the bumps and challenges, I just remind myself, it's like holding a blanket. This is normal. This is what we're going to be dealing with, and so on. And it's also complicated by the fact, and I've used the word uniquely. There are some unique dynamics, but I think if I apply my mind, not all of them may be unique. But in my experience, these are the ones that have created some special circumstances that again, go into making the road bumpy. You usually have, in terms of the alleged victim and alleged perpetrator, 2 completely competing and totally opposite versions. And very often you have no other witness, what they call the single witness scenario. And that makes it also complicated about how do you believe when people are actually, and I've had cases where each version is actually quite compelling. Another very, very big difficulty is the silencing of the victim. And we all know, and we could talk about that for ages. I've had examples where senior women have been silenced for between 12 months and 3 years in one particular set of cases that I dealt with. And the problem is that, as one writer reflects, taking harassment seriously doesn't mean dealing with it formally, but dealing with it effectively. And all of us know that a principle of employee relations is to deal with something as expeditiously as possible. And because many of the witnesses are silenced, one of my last cases was silencing from a December to a February, so it wasn't as long as other silences we've said, that means that very often when you're dealing with the case, quite a long time has passed, and especially the alleged perpetrator says, why did you take this long to report it? I'd even forgotten about what had happened, kind of thing. And that can make the alleged perpetrator extremely defensive and trying to minimize what happened because it took so long, not understanding why, the complicated set of reasons of why people are silenced. There's also very often a lot of disbelief. She can't be right. He can't be right. That couldn't have happened. I can't believe that person could be capable of doing that. So that's also a challenge. There's a term as well called empathy, which I've seen very often, maybe less so in latter years, but certainly in earlier cases. And empathy is used to describe when powerful men receive excessive sympathy in cases, especially of sexual harassment. There's just a disbelief that a person could engage in this kind of behavior. And really, this is just an introduction, and I'm sure I will, and certainly my other panelists will give more details as we go along. But I thought that was maybe a way of just saying, wow, up front, these are some of the hurdles.
Yeah, I mean, you certainly set out those hurdles I mean, it makes one think, I don't want to deal with a matter like that, because it really does sound like they are complex. And I'm wondering whether these kind of what you call competing and compelling versions and the challenge to deal with this effectively, whether the legal framework really supports that. And Keshni, maybe you could give us a little bit of insight into that legal framework that that supports that. So, for instance, I mean, how do we define harassment or bullying? Does the law assist us in defining it? And what are the structures, the parameters that we operate within when dealing with these matters?
Okay, thank you, Marion. Good morning, everyone, and thank you for the introduction, Marion. So just to kick off, harassment is defined or declared in Section 6.3 of the Employment Equity Act to be a form of unfair discrimination, which is prohibited on any one or a combination of grounds listed in Section 6.1 of the Employment Equity Act. So although harassment can be based on any one of the listed grounds, in experience in our practice, sexual harassment, particularly by men on women, is by far the most prevalent in the workplace. Bullying is a form of harassment. And because the Employment Equity Act considers harassment to be a form of discrimination, employers are obliged, in terms of Section 60 of the Employment Equity Act, to take steps to eliminate and to prohibit any form of harassment, including sexual harassment in the workplace. Like I had indicated, there are many types of harassment, and they include physical, verbal, and psychological. Bullying could be verbal or psychological. Physical harassment, some examples would include a physical attack, threats of violence, and gestures such as raising your fist to strike someone, or throwing objects at or near someone. Verbal bullying or verbal harassment could include threats, insults, constant negative judgment or criticism, sexist or phobic language, and psychological harassment may be associated with emotional abuse, and that involves behavior that has a serious negative psychological consequences for the complainant, which is often the case with verbal abuse, bullying, and mobbing. So those are just some of the examples of harassment.
Yeah.
Erin, no, you go ahead. So then just to move on, what are some of the risks of an employer if it fails to comply with its obligations in terms of the Employment Equity Act? An employer may be held liable for acts of harassment committed by its employees. So the Employment Equity Act makes an employer legally liable for acts of discrimination, including acts of harassment committed by employees. One, if the act of discrimination is committed while at work or in the course and scope of one's duties. Important there to note, the act might not necessarily occur at the workplace, but could, for example, occur at a work function or a meet. It is in the course and scope of one's duties. It would fall within the scope of the workplace. If the conduct is brought to the attention of the employer, and if the employer fails to consult all the relevant parties and take the necessary steps or steps that were reasonably practicable circumstances to eliminate the harassment. So those are the three requirements.
So there really is a risk. I mean, this act makes it the responsibility of the employer to respond when there is a suggestion or a complaint, not even only a complaint, but also a suggestion of bullying or harassment taking place.
Correct. Correct,
Okay.
Marion.
Great.
So if I can just give you a few ideas now, we can unpack these later on, but what we can do to comply with its obligation in terms of the Employment Equity Act. The obligation on employers to prevent harassment in the workplace requires employers to be proactive, putting measures in place prevent its occurrence, and if it happens, to make sure that the issue is seriously and expeditiously dealt with. Key there being proactiveness. This means that at the very least, employers should ensure that there is a clear workplace policy prohibiting harassment. It sounds like a no-brainer, but there does need to be a policy in place prohibiting harassment. They need to ensure that grievance and disciplinary to effectively deal with such conduct and deal with complaints timelessly and sensitively, and comply with the code on the prevention of harassment in the workplace. And we can unpack some detail about the code later on.
Okay. Yeah, I mean, I look forward to doing that and just understanding the code. What does strike me, though, just as we, as you explain that and how it's important to be proactive, to prevent and to act quickly as an employer. We've recently been we've been asked often by companies, and some of the companies that are on this webinar here today, to go into the workplace and train people on the code that, or the policy that has been adopted in that particular workplace, and to unpack it, because it's a policy is something written on paper, and understanding it from the different perspectives of people in the workplace is not an easy task. So, for instance, you may have a workforce where flirting or complimenting is considered to be an absolute compliment to the person who you're flirting with or complimenting, whereas it may not be appreciated as that by the recipient. So going into the real detail of what it means, and not just having a policy that is kind of pasted up on a notice board is really critical. Sure, Angela.
It is so important that before going into awareness raising, we try not to call it training, awareness raising about bullying and harassment, that we are absolutely certain that the senior leadership in an organization can honestly say that there is a zero tolerance because of such behavior, and act like that. In terms of their, just being absolutely no tolerance for this at all. Because in one large intervention we did in a large organization, I think after every one of the awareness raising episodes, people came up and shared current cases that were going on unattended, because the senior management hadn't made that commitment and didn't act as if there was zero tolerance.
Yeah, so a big challenge to make it really, really
meaningful
and meaningful process in organizations. Yeah, thanks for that, Angela. Keshni, I was wondering if this isn't a good time, though, to maybe zoom in on that code a bit, just so that we have that full context before we continue the conversation. Sorry, you're on mute, Keshni.
Sorry about that. I'm happy to unpack the code. So on the 18th of March 2022, South Africa welcomed the introduction of the new Code of Good Practice on the prevention and elimination of harassment in the workplace. And effectively, this repealed the amended Code of Good Practice on the handling of sexual harassment cases in the workplace. Now, the code essentially fleshes out the Employment Equity Act, that it places various obligations on employers. For example, to conduct a risk assessment, to implement a harassment policy, and to conduct awareness training initiatives for employees. And an employer's compliance with these obligations is taken into account when determining the employer's liability in terms of the Employment Equity Act. The code defines harassment as unwanted conduct, which impairs dignity, which creates a hostile or intimidating work environment for one or more employees, or is calculated to or has the effect of induced submission by actual or threatened adverse consequences, and related to one or more of the grounds in respect of discrimination is prohibited in terms of Section 6.1 of the Employment Equity Act. So essentially, the code is fleshing out and detailing the employer's obligations in terms of the Employment Equity Act.
Yeah, I mean, that's a lot of legalese, and I mean, it reads like that. But you know,
Yeah.
when we conceptualized this webinar, one of the reasons we thought it would be interesting to have this conversation is because these codes can become quite tick box like, you know, so employers kind of see them as a tick box. Okay, I've done this, I've done this, I've done this, so I'm fine. I'm above the law. Let's put it that way. And I guess that brings in the whole kind of conversation about mediation and really how mediation fits into being a possible tool that can be used in these disputes. So Amandla, I'm sorry, I see you've been having some technical problems. So if we lose you, we'll get you back at some point. But I wonder if you would be prepared to just chat to us a bit about mediation and how that really, I guess, segues into what Keshni has been explaining about the code and the requirements that the code puts forward.
Thanks, Marion. First, thank you for the invitation, and thank you to all that are attending. It was an incredible introduction. I almost got shocked myself. And Angela did mention that we are unpacking challenges today, and we did not anticipate one of them being connection, but we'll see. I've gotten a router, hopefully that resolves the situation. So when I first got introduced to mediation as a legal practitioner, I thought to myself, maybe not in my space as a labor law and employment practitioner. But as I delved deeper into it and having gone through the conflict dynamics training, I found that it's such a profound tool. So basically what mediation is a tool to resolve conflicts or disputes. It does not necessarily have to be in the workplace, but since we are talking about all things employee and employment related, the workplace becomes a canvas for us. It is based on the principle of collaborative problem solving, where the focus really is on the relationship, other than pointing fingers as to who's to blame for why we're here. So it's a voluntary process. No one is forced to attend a mediation. If somebody does not want to attend, or they are already attending and they want to stop, they can completely do that. So it has that flexibility. And also what distinguishes mediation from what us legal practitioners and our HR and ER colleagues are exposed to is that it is led by a completely impartial third party that has no decision-making function. Usually you would sit in a disciplinary hearing or a grievance hearing, and there is a chairperson that then decides an outcome at the end of the day. But with mediation, it is the parties that drive the process under the facilitation of this mediator. And the parties themselves then arrive at a solution or at a resolution of whatever problem or conflict they may be dealing with. So it is a bit of a deviation from what we are traditionally exposed to. It is flexible in a sense that parties have an opportunity to directly communicate with the mediator if there's something that they are uncomfortable communicating in the presence of the other party. So there's a space for that. And to address what Angela was saying on silencing of individuals, which can happen sometimes during the processes that we are familiar with. What mediation then does is offer the opportunity of urgency to these individuals so that they are able to express themselves. And it is a phenomenal tool that enables people to communicate effectively and to arrive at a fair solution for the problem at hand. And it helps people assess their own behaviors as well and gives an understanding of why somebody else might have reacted like that. So you're also sharing perspectives. Angela touched on emotions. We deal with emotions every single day. But when you bring a mediator, you are able to speak from your emotions, but also understand where the other side is coming from in a neutral environment. And what I also appreciate, Marion, having gone through the training, is that mediators are trained people. And I understand now why you need a trained mediator, because it takes a lot of skill to have to deal with competing interests, competing emotions, people who come with entrenched positions. So to have to break that down and have people really speak about what is it that they want to get out of the process at the end of the day. It's not always that an employee wants another employee to be dismissed, but it may be that I just want Amandla to stop gossiping about me. I just want Amandla to stop bullying me or withholding work from me. And you can have that conversation facilitated by a mediator. And Marion, a mediator can be somebody internal. So your managers can be mediators as long as they train, because as I indicated, mediation is a lot. So you do need that training for you to be a mediator, to handle those conflicting interests and emotions. Or it can be somebody external from, for example, conflict dynamics. Either way, the mediator's job is not to decide on the outcome, but to enable the parties to arrive at that point themselves. And what we usually find in our processes internally is that you would have the employee represented by either a trade union or a fellow colleague. With mediation, there's an opportunity to just be by yourself with the mediator and the other party and ventilate the issues. However, if you feel that you need support, then you can have a representative. But there are instances where the mediator will ask to speak to the individual parties concerned if there's something that needs to be resolved, or if the representatives are not communicating effectively. So it's that flexibility that really enables that resolution of conflict without the adversity of the processes that we usually exposed to. And another thing, Marion, about mediation is that it is it happens in confidence. So whatever happens within the confines of mediation cannot leave that particular room. So it is confidential, unlike your grievance process or your disciplinary process, where it may be recorded that this was the outcome of that process, and we can see the results. But with mediation, the mediator, basically their job is done when the parties either reach an outcome or it is decided that we cannot take the point any further. And the mediator cannot be called to provide evidence, documentary or oral testimony, in respect of what transpired in the mediation. And to a certain extent, parties cannot use what the other party said in the mediation in the context outside mediation. So it does offer those protections to people who do not necessarily want to go the route of having their sexual harassment or their harassment dispute conducted through your traditional grievance or disciplinary mechanisms. And I do believe it's a fantastic tool. And to what Keshni said about the employer's obligations, employers are urged to be proactive in the code, and proactivity can take many forms. And I believe that mediation is one of those forms that can be suggested to employees. Should they be amenable to it, then the employer can make the necessary arrangements to have the dispute mediated and see where it goes. We have had success stories, and there are success scenarios that we've also interrogated coming into this webinar, and we'll unpack them at a later stage. I'll pause here for now.
Great, thanks. That's a great kind of explanation of some of those key principles of the mediation process and how they can be used. Angela, you indicated.
Yeah. Amandla, I really enjoyed your presentation. I think you've captured some of the magic of mediation, if we can put it that way, where you can really deal with even some of these very, very tricky issues as long as you've got a very skilled mediator. And I'll never forget reading somewhere that mediation, especially as it's done by an outside third party, can kind of bring a sudden dose of common sense to a commercial mediation, a family mediation. But I just want to share with you quickly something I came across in preparing for today about dealing with bullies, especially, well, I guess, sort of serious cases of sexual harassment and serious cases of bullying. And I'm going to give 3 references when Craig will tell, or Marion will tell you more about the pack we're going to send afterwards. I'm going to send this reference so that you can read it yourself. But I just found it so fascinating. It says that one argument put forward for using mediation in harassment and bully cases is that bullying and harassment represent a serious loss of self-awareness leading to the conscious or unconscious misuse of power, expecting that there be no pushback. That really is very, very interesting. This is what you're dealing with. I mean, sometimes we flabbergasted at what we think, how did so-and-so ever expect no pushback or comeback on that behavior? The writer goes on to say mediation can confront the accused with the direct consequences of his or her actions and force him or her to explain their actions, which can be very powerful. And you alluded to that. But I just want to add something to that, which I just want to give it to people to think about. While I agree with that view, I would question the assumption that a mediation process always produces a sudden dose of common sense or insight. We know that it can. We definitely know that it can. But in my experience of dealing with bullies, the exact circumstances which the writer describes, which is lack of self-awareness, and renders the bullying feeling omnipotent, are the circumstances that may indicate a very defended, often narcissistic person who remains impervious to feedback and simply unable to see their impact on the bullied person. So I'm agreeing with all you said, but I'm just putting up a red flag that some personalities just will not respond to the magic of mediation and, allow themselves to get insights into their behavior, which is really unacceptable, and they can remain, especially if narcissistic, very defended. Thanks.
No, before you jump in, Mario, no, certainly, Angela. And that's why when we are talking about mediation, we're not necessarily saying we are nullifying all these other processes, right? So should mediation fail? I see this a question from Elizabeth also to say, what then should happen if mediation fails? If mediation fails, then you follow the processes, your internal processes as informed by your disciplinary procedure. But what is important to note is whatever transpired during mediation is bound by confidentiality. So you will attend to your grievance hearing or whatever hearing as per the code. But just parties need to be careful to say, but you can't say, yeah, Amandla shouted at me because she has a drinking problem. It has, right? Because I divulged that confidentially during a protected process. So you have to let the formal processes, the internal formal processes run their course. And the chairperson would not be the same person who mediated the dispute between the parties. Yeah. It will definitely have to be somebody else that is different, that is impartial, and that is completely independent. Okay. And while still on this topic, I also see that there's a question to say, but the victim might feel that, well, it's the company that is paying the mediator. So that might cause some discomfort. It is not different from grievance hearings or disciplinary hearings when external third party is appointed to assist as a chairperson. There will always be that discomfort, but it won't be anything unusual. It is already happening. What may be important for HR or ER is to emphasize that, similar to chairpersons, they are independent, they are impartial, they have been appointed, they have terms of reference. It has nothing to do with who's paying their bill. But if parties want to pay the mediator bill, they're more than welcome to do that. But I don't see any employee volunteering to pay a mediator bill when the employer is saying, listen, I can bring a mediator to resolve this issue. So there's
also,
always going to be that hesitation.
Yeah. And also, I mean, from what we've understood from the code that Keshni mentioned earlier, is it is the employer's responsibility. So it's a benefit that can be enjoyed by all employees. Yeah, I mean, while we're on this subject, and there've been a couple of questions in the chat about internal mediators. And when we speak about internal mediators, we mean people within the organization or the company who then step into the role of playing a mediator. And if you're a mediator, that does mean you're stepping into a role of being someone who's independent of the issues. So in a company, you'll have to be very sure that the mediator is someone who both parties trusts, and trusts to hand over the process to that mediator. We've had great success in training internal mediators. So there are a number of large institutions where the institutions feel it's valuable to have a cadre of leaders at different management levels who have the skills and who have the confidence of the organization or company to intervene internally. And it does seem to work extremely well. We keep contact with those companies and organizations, and those mediators take their role extremely seriously as a third party independent, even if it's within the company. So it's someone from a different division, a different department, a different city. It could even be, we've also at Conflict Dynamics trained a number of the development bank's internal mediators. So they have mediators who they make available internally, but also externally to member states to get involved in assisting with dispute resolution. So it is something that can really work well, but it has to be very well thought through, and the structures have to be set up internally so that people know what they're buying into and know what the parameters are that the mediator is operating within in terms of that confidentiality and in terms of the skills that they'll use to try and resolve the matter. Angela?
Yeah. Can I just raise another couple of conundrums? Sorry, I keep to be going on to conundrums, but they really are very important here. Just about the whole issue of confidentiality. We know that every policy in an organization says that anyone dealing with these sensitive cases, any cases, but particularly these sensitive ones, they must remain confidential. So the manager involved or the HR person involved, we know that they must remain confidential. However, in real life, what happens is this. Something happens between Angela and John. Let's use a sort of stereotype, Angela and John. And John then often goes around creating allies and lobbying people, saying, you can't believe what Angela has accused me of. Can you believe it? You know me, I'm not that kind of person. And they will be spreading what has happened and their version. Similarly, often the alleged victim will be doing the same thing and going around lobbying allies and saying, you can't believe what John did to me. I am so absolutely gobsmacked and hurt and offended, and so on and so on. This is very natural human behavior when people are feeling that they need to be defensive as a victim or as an alleged perpetrator. And Amandla, often then everybody else is professionally remaining confidential, but the parties themselves have been spoken to by either of the people involved. And that has a profound, that's very often why it becomes even more complicated and even more divisive. And to your point, of course, what happens in a mediation, in whatever sphere the mediation it is happening, it should be confidential, but very often, especially if it fails, we have known, and I've known many in a family mediation situation where parties have not been, yet they can't unhear what they've heard in a without prejudice situation during a mediation, but at another interaction, people can become very indiscreet and can, in fact, ignore the rules around confidentiality. So that is just something else to bear in mind.
Absolutely. That confidentiality and how it's managed is it's absolutely critical and has to be thought through, especially internally in organizations, if they're going to be using these skills. I mean, I've had a couple of situations where post-mediation, whether I reach settlement or not with the parties, the HR practitioner or the ER practitioner wants to know what happened during the mediation. And I've actually been contracted by them to come in and mediate. So it's a very, very difficult relationship because they commission the HR or the senior manager or the ER practitioner internally contracts me to come in as a mediator and do this work. So it's really important that upfront mediators are explaining their role to the companies who are contracting them and the individuals who are contracting them, because you're not contracted by the employees. You're servicing the employees and you're assisting them, but the person who's paying your bill is the company. So it's important to do that work up front to explain. I'm coming in as an independent third party. I can only report back to you what the parties agree. I can report back to you. So making that very clear up front and being honest to your undertaking when you do give feedback back to the person who's commissioned you. Yeah, I mean, this is a lot of detail, and I mean, I can just give a bit of a plug. We are training workplace mediators in May on a 3-day skills program, which is specifically focused on people who need to know how to mediate and how to contract mediation internally. I think the reality is it's becoming more and more of a thing. So it's important that more and more people are very familiar with the process and able to use it effectively. I am a bit concerned about time, and I know there's a lot that we still want to get through. So I was wondering if we can just shift the emphasis slightly away from mediation again. I mean, I, of course, would love to sit and chat mediation for the rest of the time, but just to respect the fact that we are operating within this legal framework, and the legal framework specifically requires investigations. And investigations, I mean, it's one of those conundrums that we were discussing before the session. Here we have mediation, which potentially could assist, but in cases that fall on around the 10-12 range that Angela was speaking about earlier, you know, on cases that are extreme cases of bullying or harassment, it may not actually be appropriate to be mediating those disputes because of issues that have been raised in the chat, for instance, of power imbalances, silencing, those type of issues. So just a little bit of a focus on investigation and how one can get the most out of the investigation process, just to give the other side of the other option, really. Keshni, if you could give us a little insight into just what the practical considerations are when you're investigating a matter.
Sure. Thanks, Marion. That's a bit better now. So at a very high level, an investigation is just a fancy word for a fact-finding process. The point of the bottom, of the issue, and to establish or try and establish the truth. It often is taken by employers to holding a disciplinary hearing, and this is done to determine whether there is factual evidence to show that on a balance of probabilities, the employee or the alleged perpetrator committed misconduct. Generally, when you conduct an investigation into allegations, harassment, sexual harassment, you meet with the complainant first. Often there could be more than one complainant. Establish exactly what the complaint is, the who, what, when, how, where, that sort of detail. And you do that prior with the alleged perpetrator. We have had instances, although it's not very often, where the perpetrator refuses to be interviewed. And then you would make sure that you advise them that there could be negative consequences or adverse consequences of them not sharing their of the story. And you do this in order to obtain the perspective of all the parties involved and to arrive at a well-reasoned conclusion. And in conducting your investigation, you would try and establish whether any policies have been contravened, or whether the law has been contravened in your very serious sort of sexual assault, rape investigations. When conducting the interviews, like Angela and Amandla and Marion have touched on, confidentiality is key throughout every stage of the process. And after concluding those interviews, you would then compile an investigation report summarizing the evidence on a balance of probabilities. So this is not a criminal investigation where you have to establish beyond reasonable doubt. It's on a balance of probabilities. We find in the more serious cases, or where someone quite senior is implicated, that the employer chooses to appoint an external service provider to conduct that investigation. It would depend on the nature of the alleged misconduct, and it would depend on seniority of people involved. And I think the questions come up quite a bit about alliances within the organization. So, for example, the person who has allegedly committed the harassment or the bullying or the assault is someone in a management position who possibly has alliances with people in the HR function or people who could be conducting the investigation. Then it would be a good idea to appoint an external service provider to conduct that investigation. I hope I've answered your question, Marion.
Yeah, I mean, it does raise the issue that what then happens with that report. And at some point when that initial investigation, fact-finding is done, someone needs to make a decision, okay, what now? Now that we found this, what now? So what are the next steps?
So upon receipt of the report, depending on the findings, the employer will decide whether to proceed with a disciplinary hearing. And often, the disciplinary hearing is in respect of the complainant for false allegations or malicious allegations. It's not a pleasant thing to deal with, but we have found in many of our investigations that not only are the allegations false, but they are in response to or in retaliation for a performance management process or a disciplinary process. And in those instances, as much as the employer has to protect its employees from sexual harassment, an employer must also protect those who are falsely accused of something as serious as sexual harassment, for example. So depending on the findings in the report, again, depending on the seniority of the employee involved, we sometimes recommend that the employer conduct a less formal disciplinary process. For example, they provide the report and ask the employees to make representations in writing. As long as you have that opportunity to make the representations, it doesn't have to be a full-blown face-to-face disciplinary hearing. It just depends on the nature of the misconduct, whether the report is clear and detailed enough to enable the alleged perpetrator to make those representations before final decision is made. And if I can just mention, Marion, there is a difference between a false allegation in the sense that someone perhaps misinterpreted a joke or misinterpreted a hug or, a squeeze on the shoulder versus a malicious allegation where it's completely made up because this person was now being faced with some sort of performance management process or a disciplinary process, or they were just not getting along with the manager. With the malicious ones obviously being very serious. And we must also be careful as employers not to punish someone just they misinterpreted something. In that case, education would be more important, apart from disciplinary action. So sometimes there's a fine line, but often it is clear that it was a malicious complaint, and those ones must be dealt with seriously.
Interesting, fascinating. But I mean, it sounds like what you're saying, it could go anywhere at this point, it could go to discipline, it could go to further investigations or further submissions. It could go to an education process to just make everyone aware of what is or isn't acceptable. And it seems to me like it could also go to mediation, just from my perspective, where at this point, after the investigation, you can say, look, relationships have been soured. People don't know how to behave according to each other. Teams have been affected by this. Is there a way of now pulling people together to try and develop a new way of being post a specific kind of uproar, So that's fascinating. Thanks, Keshni. That gives us a good sense of kind of those legal steps that are possible. My question is now, what about mediating before the investigation is done? When would one do that? And I mean, this is a new question that we haven't actually discussed prior to this session, but when could it be appropriate to mediate before the employer investigates a matter? Angela?
I think, well, we haven't applied our minds to this one, but just thinking on my feet now, it would never go straight away to a mediation, even if only there is a rather superficial investigation where both parties are saying, no, we fine. We understand that other people can be more affected than we have when we shared that joke or had a drink too much at the Christmas party or what else it might be. But I think to what Keshni has said, it is normal. It might not be a very in-depth investigation. I mean, the most important thing, I think, in choosing mediation is where the relationship is not damaged to the point that it cannot be resolved or fixed or restored between the parties. And so if both parties are saying, no, we're happy to go to mediation, we just had a misunderstanding, because in mediation, it is very difficult to have one party who says, I don't need to be here, this is not my fault, I had nothing to do with this, and is in the blame game, and the other one is saying, well, I sort of am, there is some joint contribution if they are being honest. I last year just advised some senior people with in the financial sector not to go ahead with mediation because there wasn't sort of joint culpability on both parties. So if that helps, that's what I'd say about this. No necessarily need for an in-depth investigation, as long as the parties, you get the sense that the parties can have their relationship restored.
Okay, that's very useful, Angela. I mean, we've had a couple of mediations come through conflict dynamics where the employer or the company or organization values both people very, very highly. They want to retain the skill in the organization, yes. And they almost use mediation as an encouragement to get these two employees who have obviously come to blows, get them to think about their relationship in terms of the value that they have to the company. So they've been, and that often also happens at quite a senior level, where senior members of staff are at loggerheads, and the company sees third-party mediation as a sort of external mediation as a way of really unpacking that relationship and seeing whether there are ways they could flex their behavior in the interests of their careers within the company. You know, so that's there've been a couple of those where it's worked really well.
And Marion, especially, and I'm sort of flogging a dead horse, but just to go on, when I had a CEO once asked me to see two senior people, and he said to me, they are both fantastic and valuable to the company. So when I went in and did the mediation, I could say that genuinely, because very often it is not only about sexual harassment and bullying. We will be briefed to mediate a matter, but there'll be a kind of a signal that you'll get. It might be a direct saying, actually, if you choose between, you know, Jim and John, it's actually John who's more dispensable to us. But to honestly say both are valuable really does assist in a dispute resolution.
But again, just to highlight the point, if you're mediating, if you're entering as a mediator, you have no agenda.
Yeah.
So no matter what the company told you in terms of
Exactly.
preference lies, or where you're there to try and resolve a matter between the two people, or the team sometimes even that you're working with. So just a heads up on that front. Good. Yeah, there's one question that I think might be quite interesting to address now before we move on to some other issues, and that is the issue of taking criminal, whether the company, I mean, Hendrik, you asked the question, in sexual harassment cases specifically, does the company get involved in opening a criminal case? So that's quite an interesting one. And Keshni, I don't know if you've had to deal with that.
The company wouldn't get involved, but in providing the necessary support, the complainant should obviously advise them of that avenue. And you would not be precluded as an employer from conducting investigation, sort of parallel to that process. We know, unfortunately, in South Africa, how long these criminal investigations take. And the difference being that in a civil matter, such as an employment matter, it's the burden of proof is on a balance of probability, to a criminal case where it's beyond reasonable doubt. So the employer would not be initiating the process, although in supporting the victim or the employer would advise them of that avenue.
And your support may not only be in advice, but the company may choose to support in other ways, in other support, especially if there's a reputational risk to the company in terms of the issues that are being dealt with. Okay.
Correct.
Right. Good. Yeah, I mean, there's one other area that I thought it would also be quite interesting to chat about in more depth. And Angela, you have raised a few red flags already, but I know in our preparation you raised a few others, and some interesting kind of critiques of the mediation process, especially when we're thinking about that range of bullying and harassment that can happen. It's not a black and a white thing. It's so useful to think about it as a range, and where the bullying and harassment fits onto the range, what is appropriate under those circumstances. But I think, just speaking about some other red flags about using mediation as a way of dealing with maybe extreme bullying and sexual harassment cases.
Okay. Well, clearly, if one party refuses to participate, then you wouldn't be able to carry on with a mediation process. Some people say when there's a huge differential in power between the parties, that can render mediation less effective. My response to that, as a mediator who's mediated some of these cases, is that, well, the role of the mediator is often, and I've done not around bullying and harassment necessarily, but I've done cases in which a very powerful MD sat with quite a junior, and the MDs had their lawyer there, and it was my role then to create a balance in the room in terms of power, and allow the person to often go and seek advice from friends, or in this case, her son and her lawyer on the telephone outside. So, you know, you can deal with a balance of empower. When, as one writer says, it's not recommended when mediation trades justice for harmony. And this really made sense to me because a few years ago, and I've done a few cases for this particular person, somebody I know runs a small agency, and he had a case of sexual harassment, and he said to me, just get rid of this problem. Just make this problem go away. This is making my life so difficult. Please get rid of the problem. And he wanted me to come in and do some magic quick solution, which would mean immediately relationships would be restored. And, you know, where a person's looking for that, you might sometimes find that there are limitations, and you have to manage people's expectations. It's interesting because one of the, as Amandla so well put it, one of the medical outcomes, or one of the medical ingredients in a mediation, is that who is telling the truth about a situation doesn't have to come into it. That is indeed a problem when one of the parties says, I didn't do what I've been accused to do. I want my day in court and I want to be exonerated. I don't think mediation's going to go well. I'm not saying, especially very experienced mediators couldn't deal with that and change it, but that would be a challenge going forward. We've spoken about compromised confidentiality, the without prejudice. We've also spoken about you can't unhear something once it has been said, especially if there is malice around. And people often will maliciously go and repeat something at a court case or in an arbitration or at a formal inquiry that they heard during mediation. Strange, I mean, in your average mediation, your normal mediation, I should say, not average, your normal mediation, the values of cooperation, collaboration, good faith, good will is inherent in the mediation. And if the parties don't come in with that because of the high emotions, the anger, the hurt, the pain, whatever. But again, I can hear a lot of my mediation colleagues saying, we deal with that all the time. We are used to that very often. That's why we have to build rapport quickly, etc., etc. We can deal with that. So, you know, but it does, where one party would be, I guess, the alleged perpetrator in many cases of bullying and harassment cases. One of the magic moments in mediation is getting parties from positions to interests, needs, fears, and concerns. And that's where you unlock the common sense, the magic, etc., etc. When one party is clinging on to their position, I did not do it. I did not call that person XYZ. I did not withhold work from that person. And you can't get them to open up and leave their positions. You might have to go for another kind of a process. What I've often found helpful is to say to myself, I haven't really been asked to formally mediate, but I've been asked to resolve the dispute, and I reframe the intervention from a formal mediation process rather to a facilitated conversation. And I often find that using a lot of the techniques of mediation will unlock something between the parties where they seem stuck and now feel able to move on. But one, and we've mentioned this before, but just to say it as my last point here, one key ingredient here to facilitate a difficult or courageous conversation is to get parties to move from it's all your fault to the idea of a joint contribution can be very tricky if it looks like one person caused the behavior and the behavior landed on the other person, kind of catching them off guard or out of the blue. They might say, and this often happens, I was sitting at my desk, minding my own business. I heard something on my phone, and suddenly I've got an offensive meme. I did nothing to ask for this. Now suddenly I've become a victim because of something unexpected. And to get that person involved in a conversation can be quite tricky. Thanks.
Great. Anything to add, Amandla?
Thanks, Marion. Before I can share my 2 rands, there's a beautiful comment by Tola. I hope I'm pronouncing the name correctly, to say mediation is not always an appropriate resolution method for workplace harassment. I completely agree. And this is why we need to assess every case on its merits. And that's why Angela said it would not be advisable to mediate before an investigation. And even after investigation, if you find that the misconduct or the allegations are so grave that mediation is not appropriate, then even if you do go to mediation, you might not find the resolution that you need. And in those cases that have criminality to them, it may not be appropriate to mediate.
Yeah.
But Marion, something that we have not stressed, although Angela touched on it, is the timing. Timing is very key. Now, there are no hard and fast rules as to when you can mediate, but it's very important that ER, as people who would be advising employees on mediation and as legal practitioners who also lend support to ER, is to understand that if you find during your investigation that this is a matter that can be resolved via mediation, then it would be best to advise upfront that this can be mediated and motivate why that is the case. Because sometimes you'll be telling an employee, let's go to mediation, and they don't even know what mediation is. So if you explain mediation in comparison to a grievance or a disciplinary hearing, then they might be able, they might be more amenable to mediate. Because sometimes, like I said, you might find that the other party does not necessarily want an outcome that leads to a written warning or a dismissal of the other. It's just a matter of, I want an apology and for this particular individual to stop what they're doing. But obviously, like I said, you assess a case on its merit. Is it a case that we can mediate, or this needs to be taken seriously? And another thing we need to look at is that our workplaces have rules. So now, if a rule is breached, then is it a situation where the employer wants to make it clear that the breach of this particular rule is not condoned and a decision about right or wrong needs to be made? That's when we are setting precedent. Then the employer assesses that, and if we need to set a precedent, then mediation is not the appropriate platform, because mediation is confidential. Whatever happens there will not be divulged. So if you need to set a precedent and have that consistent application of discipline in the workplace, then mediation will not suffice. Also, if it's a discrimination issue that the employer wants to be investigated, it may not be wise to address that through mediation. But it will depend also, after the investigation, what is the outcome? How can we resolve that? Because after the investigation, you would have spoken to the people that you need to speak to understand what the issue is really about. Just like Keshni indicated, that it is a fact-finding exercise. Now, let me give you a scenario, Marion. We're dealing here with a hostile work environment where a group of employees has come to senior management to say, listen, this is our experience. Every Monday morning when we attend our team meeting, this particular individual makes discriminatory comments, and we just want to lodge a formal grievance now. We've been saying this is wrong, but they're not listening. We want to lodge a formal grievance so that he understands that this is serious. And one of the ways that the employer can deal with it is to say, okay, let me have a conversation with this individual who's making these discriminatory comments. I've heard, you hear both sides. That's that fact-finding exercise. It's very informal. And then invite the parties to mediation, because they still have to work together. And if both parties voluntarily agree to mediate, then that process unfolds. And it may be that he apologizes, and then there is training after that. That's where that educational element comes in that Keshni mentioned, because of this process of mediation. But what is important is that the employer understands that there is some discomfort, and what is it that we can do to resolve that discomfort or to address that discomfort. Now, with respect to the timing, Marion, there was a recent case, a High Court case, in the judgment of Celia versus Road Accident Fund. And I do believe that you posted it up on your social media pages. It's an incredible case that reaffirms that mediation, well, they're speaking of mediation under Rule 41A of the High Court rules, but I suppose it applies also in the workplace situation, that mediation can be pursued nearly at any stage. And they highlighted the flexibility of mediation as an effective dispute resolution. So this means you can mediate before you hear an actual grievance, or you can mediate after you've heard a grievance and you find that the parties really are at idem on certain elements. It's just that we now need to mend the relationship. And then the mediator would be able to facilitate that conversation as to how these parties then continue being in this relationship or working together. So that's my take on that, Marion. I am mindful of the time, and I want to continue having this conversation a little bit longer.
Yeah. No, that's extremely useful. Thank you. And I guess it does get to the point. I mean, there is one aspect of Tula's comment that hasn't been raised, and that's the domestic violence instance. And I guess it links back, Tula, to the comment that I started with at the beginning of this session, with how workplaces have become a place of activism. So employers need to take on certain issues, and domestic violence falls under that kind of arena. And I have seen best practice notices being put out that it is the work, if domestic workplace is happening, domestic violence is happening with either party relating to that violence, the workplace does have a responsibility to deal with it. So that's a challenge, I guess, to us as employers, as you know, how far does our activism go in healing a society or healing a particular problem. Yeah, I mean, I think in conclusion, what I'd like to do is just give all our panel members an opportunity to kind of wrap up with what you would consider, panel members, your nugget of practical advice when it comes to dealing with bullying and harassment. if we could do a quick round of the three of you, just in wrapping up this conversation. So your nugget of wisdom in dealing with these issues. Keshni, can we start with you? Sorry to put you on the spot.
No, so considering that I've dealt with the sort of legal framework, I think for me, what I think is most important is the employer need to be proactive, and secondly, that the process will depend on the scale, seriousness of the alleged misconduct. So, like Angela mentioned at the beginning, sometimes a less formal approach is appropriate. Whereas if you have an allegation of rape, there's no question about the sort of process that you need to follow. So just to exercise that level of discretion as an employer in how to approach the complaint. And then just to mention that Bowmans does have a harassment prevention pack to assist our clients to comply with their obligations. And that contains a guidance note, application of the code, a template risk assessment, a template harassment policy, a poster on the different forms of harassment, and an e-learning module, which can be completed by employees and which is available through a secure web page. And it goes to the employer's obligations, obviously, to ensure that its workforce are trained, and that an employer keeps a record of that training. And we will then post the email address that you can contact Bowmans through in order to inquire about that harassment pack. Amandla mentioned this is a topic we can go hours about. So I hope that this was helpful, and I'm sure there will be many questions.
Great, thanks, Kesh. Amandla, can we go on to you? Your pearl of wisdom.
Awesome. Thanks, Marion. First, again, thank you for having us. This has been such an enriching conversation, and I do pray that we take it offside and continue having it and exploring how mediation can assist in workplaces in respect to addressing harassment. Not all harassments are the same. Obviously, we would have to ascertain what is it really that mediation can assist with, because one thing that is important, employers are the currency of any organization. And we find that employers have invested in employee wellness programs to assist their employees in terms of dealing with such situations. And it can't be something that is valuable in terms of retaining people, and also making employees understand that they are heard, they are seen, and they have the space to ventilate their issues should they be up for that. So what I'm taking from this conversation is that it's not an easy thing to do, but it's a worthwhile thing to start investing in and thinking about it. Whether it's something that you are currently doing or it's something that you wish to do in the future. I mean, forward thinking is always the best thing to do. And just let's continue engaging. You can contact any of us should you have any question that we may not necessarily be able to address in this platform. We are on LinkedIn, and I suppose you can search us and find our email addresses, and we will be more than delighted to continue having this conversation. Unfortunately, Marion, Keshni, and I are not just legal practitioners, but then we're also trade mediators. So we have we have around knowledge of both these topics. So I would like to engage more with our peers on this. Thank you, Marion.
Thank you, Amandla. I mean, what you're saying and the emphasis on encouraging conversation and encouraging that ventilation. I heard a wonderful term recently where there's been a lot of emphasis on encouraging employees to speak up, speak up, but there needs to be a lot of encouragement of employers to listen up. And mediating is a way of listening up, of allowing that speaking to actually mean something for employees. Yeah, great. Angela, last but not least.
Well, I've got a couple of thoughts. First of all, it's each case on its own merit. One size doesn't fit all. So, and related to that, please consult outside subject matter experts with these, as like an addiction or other mental health issues. Please consult the experts here, because you really will get a lot of very good advice and guidance. Don't rather consult and before you make a decision. So each really case on its own merit. And then I just want to make my final point. I'm extrapolating from, I do a lot of work on race disputes, and they really are very, maybe even tougher than these disputes. Please, it's so much easier if you engage with managers or people in organizations who are able to deal with complexity. In other words, not binary thinking, that they can hold two contradicting thoughts in their heads at the same moment. That person, that ER person or MD that you're dealing with, if they're able to do that, they will find dealing with these complex and challenging matters less stressful. So thanks, colleagues. I thought that was a really great, thanks to conflict dynamics, that there's really great ventilation of many of the conundrums around this very challenging field.
Right, thank you, Angela. I have noticed that there is some hands being raised, sorry, in the among our participants, and I'm delighted to see most of you have stayed the full 90 minutes. And I am concerned that we may be missing something, because I have kept an eye on the chat, and as have all the participants. But if there's something else you'd like to raise, a suggestion to be made, I mean, the one topic we haven't spoken about are what are the essential skills of a good mediator. And we wanted to discuss it, but time just has run out. So maybe that's a next step, really, on looking at mediators and how they need to be skilled in order to fulfill their role effectively. Because the one frustration as someone who works in this industry is that everyone thinks they're a mediator, and sometimes people can do more damage than good if they get involved in specifically these types of very sensitive matters, when they haven't received the necessary training and skills development to do it. So that is certainly a topic we can pick up on. But if those hands being raised are additional questions or additional suggestions, please just drop us a note. You know where to find us. Yeah, there are a couple of other opportunities. I'd just like to use the opportunity. So we do train accredited mediators to become workplace mediators, and there is a course that is scheduled for the 26th of March. We'll put that on the note that goes out as well. And then we can train people who are not accredited mediators, who particularly want to only do workplace mediation. We'll be training that course in May, and we'll send the details of that out to all of you as well, including the reference to Keshni's harassment prevention pack, and where you can access that. And we will include the references that Angela mentioned in the note that goes out after the event. We also do make the recording available to everyone who's been here. So if you want to go back and check something out, you could do that, because that recording will be available. Yeah, I mean, I think that all that's left is for me to thank all of you as participants. It's been a lovely morning. Thank you very much to Keshni and Angela and Amandla for the effort put into preparing for this conversation, and to Craig for hosting us here. And we look forward to seeing you at the next opportunity.